All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. Good morning. This is the time set for oral argument in our cause number CV14-0708, Glasser versus M&O Agencies et al. Counsel, we're recording today's proceedings, so when you step to the podium, please identify yourself and the client you represent. Each side will have 20 minutes for argument, and Mr. Dow, as appellant's counsel, you're responsible for watching the clock and reserving any time for rebuttal that you may desire. We've read the briefs and we've conferenced the case prior to argument. So with those preliminaries, you may proceed.
Thank you. Good morning, Your Honors. David Dow here on behalf of Elliot Glasser, the appellant in this matter. The essence of what occurred here, just in summary, is the trial court granted summary judgment for M&O Bradley. Mr. Glasser has appealed that decision. M&O Bradley was denied attorney's fees and has appealed that decision. Mr. Glasser filed this lawsuit against M&O and Ryan Bradley after they wrongfully canceled insurance coverage for commercial property owned by Mr. Glasser. He has alleged they failed to follow the instructions to obtain and maintain the property insurance and never notified him of the cancellation. There are other claims, but we are here based on the judge's grant of summary judgment here.
Can we kind of cut to the chase
Sure.
and tell me the state of the record, what the record discloses was being done at the property during the 60 days preceding the loss?
Okay. In this particular matter, Mr. Glasser had arranged he was transferring it, or he was changing it from an automobile dealership into a commercial viable facility.
Right, and I know there were activities right after he purchased it, which would be outside the 60-day period. So I'm trying to figure out what the record discloses as to activities roughly from May 6, 2010 to July 6, 2010.
Yes, and most of them did occur during that time because he purchased the property in April and the vandalism occurred in July.
Wasn't it March? I thought it was March that he purchased it.
I think it closed in April.
Okay, all right. So
So
yeah,
it's a very short period of time here after purchase.
Although you talk about some things that happened after the loss, and clearly those would not be contemplated under the exclusion exception.
What he had done, of course, initially he had changed the locks. He'd removed the logos. He had removed the tire or the automobile jacks that had been in there as an automobile dealership to change it to more of a commercial facility.
Oh, the service area.
In the service area, yes, yes. He had repaired the roof. He'd repaired the ceilings.
Did the roof repair happen within that 60-day period? I don't think it did.
I don't think it did, Your Honor.
So that's what I'm trying to figure out.
Yes, the others did, Your Honor. He had tested the light fixtures. He had removed, besides the hydraulic lifts, he had removed shelving, which was built in there. He had begun repairing the floors, and he had installed fencing and landscaping, and the fencing had been at the request of the insurance company. So he thought he was conforming with what they needed to do. They certainly didn't tell him at any point that you need to change the insurance or anything like that. Mr. Glasser's an elderly 82-year-old man. He had dealt for a long period of time with this insurance agency. This is not the first occasion. He had a long-standing history with them. He trusted them to do what was appropriate under the circumstances. That vandalism occurred on July 6th of 2010, or at least that's the first date that I have, Your Honor. And most of this did occur prior to that. We don't believe that the building was vacant because it was a substantial amount of time was being done to redo these things and convert it from a automobile dealership into his, I'll call it, world headquarters. Mr. Glasser is an individual who buys and sells beads, rocks. He's quite a large operator in that on the internet, and he needed to remove this to make it viable and change what occurred here. And incidentally, the police did collect commissions for this, so that it appears like they were affirming that what he was doing was appropriate.
Okay, let's go back and focus on the word renovation. Judge Warner found that as a matter of law, the activities at the premises were not renovation. Do you know, and secondly, what is the definition of renovation? It's not defined in the policy, so how do we assess whether as a matter of law this work was renovation or not?
Well, I think that could be, whether it's an ambiguous term or a term to determine for the jury, I don't know that that is a matter of law. It may be a matter that both sides are allowed to present their evidence, should they have evidence on that, and that should be for the jury to determine. Couch on insurance generally seems to think these are questions for the jury as to whether there's been appropriate construction, renovation, or anything like that. And we do have, certainly they can contest whether this was a renovation, construction, or whatever, but we do have evidence on that, and we believe that should be an appropriate matter for the jury to determine.
What's your evidence, if it's separate in part other than what you've already told us?
Well, no, that's it, Your Honor.
Okay.
Those items and the ones listed in the brief there, we don't have anything else, and we just believe that under the circumstances that this should be something for a jury determination as opposed to a matter of law, which seems a kind of a harsh determination under these circumstances. And really not in conformance with the normal construction of construction of insurance policies against the insurer and against the person who's got this duty also as the agent, as their agent, to be fully truthful and give them full and complete information.
Well, but there would be difference with what's in the policy as opposed to the agent, and at least it doesn't appear that you have, your client has included the carrier.
We have not, Your Honor, because the carrier did, and that would have been a separate issue. I was not involved in the initial matters on this case. And we believe that the trier of fact is the one that does this. There's not a lot of Arizona law on this topic. We recognize that. We have had to reach out and look at other jurisdictions and see what they have done. Not in the exact situation, but certainly analogous situations where things have been removed, where stages have been removed, where there's been minor renovations and things like that. It's not like the whole building needed to be renovated. That doesn't say that in the cases, and it doesn't say that in the policy. We did rely on the TRB investments case, which seemed to indicate that this should be a question normally for the trier of fact. We also relied on the Bellich case, which said whether there was renovation or construction, where there was the removal of the stage and some coat racks, probably could constitute renovation, but at a minimum, the summary judgment motion should have been denied.
One of the reasons I asked you the first question about what was done during the 60 days is I think there's certain very low-level acts like changing light bulbs or washing windows that we might all agree as a matter of law are not renovation. So I was trying to focus on what was in the record to create a factual issue as to those 60 days. And I think you've already told me what you believe the status of the record is, and we'll hear from the appellees on that too, I'm sure. I'm
sure we will, Your Honor. We just believe that given that I'm sorry, I apologize, Your Honors. I'm rushing a little bit this morning in a very unusual situation because I had a large matter in front of Judge Viola that took a lot longer, and I had to run over here, and I didn't get this killed along the way, Your Honor. So I will make sure that is done. And we believe that even the other cases that have been cited all seem to say that this should be a question of fact. Even one of them relied upon by the appellees seems to say it's a question of fact because the trier of fact determined it in their favor, but that was after the trier of fact determined that. This is an appropriate case for the court to remand this one with the instructions that the summary judgment be reversed. Additionally, and just I want to touch on this briefly and reserve the rest of my time. As far as I'm assuming you want me to argue the attorney's fees matter also.
You can do that now, or you can wait. I mean, we're not
You know
gonna-
what? I'll reserve that, Your Honor, and I'll reserve the rest of my time.
Okay, thank you.
Thank you.
Thank you and good morning, Your Honors. Miles Hassett on behalf of the Mahoney Group and Bradley. Present with me is Julie Moen of my office on the briefs, and Mr. George Claypool of the Mahoney Group is present also. Judge Downey, I do want to get to your question in just a minute, but let me start off and articulate the core idea here behind the vacancy clause in the policy. The central concept is that the insurer does not want to cover the increased risk posed by vacancy at a property. Generally agreed across the cases that vacancy of a property is going to expose it more considerably to criminal activities such as the kind of theft and vandalism that occurred at this former automobile dealership in Scottsdale. The way the policy reads is that if the property is vacant for 60 days or more, there's not going to be coverage for theft or vandalism. There is an exception to that exclusion. The exception is for buildings that are under construction or renovation. The law in Arizona is that it is the insured, here Mr. Glasser's, burden to bring forward facts that place this within the exception. So the burden is on them to establish those facts. Now, Judge Downey, to your question about what happened when, I would give you what we have from the record. So Mr. Glasser closed on this property on March 22nd of 2010. Within a couple of weeks, according to his testimony and that of his employee, David Holwerda, he removed the hydraulic jacks that were in the service bays. He rekeyed.
But that was before the 60-day
right.
period?
I'm going to first talk about the things that predate the 60-day period because it is important to distinguish between those things. So the hydraulic jacks came out, the locks were rekeyed, various items of what Mr. Glasser described as quote-unquote Toyota's crap was removed from the premises, which included signs, displays, and things of that nature. So all of that is gone before the 60-day period begins to run. What then happens in the 60-day period? Maybe I'll deal with after the 60-day period. The record is absolutely clear, and this is in the Holwerda deposition, that the roof repairs occurred after the July 6, 2010 date. The roof was damaged as a result of a monsoon storm after the theft and vandalism loss was reported. So anything to do with the roof is after the 60-day period. In the 60-day period, I tabulate the following: changing light bulbs, cleaning carpet, touching up paint, repairing doors and windows, which are damaged, incidentally, as the result of vandalism at the property. Mr. Glasser said there were at least 10 police reports on this property prior to the July 6, 2010 loss report. So doors and windows are being repaired. Leaky toilets and sinks are being fixed by another employee of Mr. Glasser's, Helmut, and they also are engaged in moving shelves from the second floor of this 20,000 square foot building onto the first floor, and they are patching in places the walls and the floors where screw holes were left from removing Toyota's signage. So that's what's happening inside the 60-day period, and this is in the record as well. We spoke with Mr. Holwerda. We went through a supplemental discovery and briefing on this issue so that Judge Warner was fully advised on it. This is at page 71 of the Holwerda deposition. Question, line 16. Question, all right, So, fair to describe what you were doing between March and July of 2010 as general cleanup and maintenance of the property, including landscaping and so forth on the outside. Fair description. Answer, yes. Question, yes. Answer, fair description from March to July. Question, and you were not involved in doing things that you would describe as tenant improvements, such as building or moving walls, constructing things inside the property or outside the property. Answer, correct. So here we have the key witness for Mr. Glasser describing what was happening at the property as general cleanup and maintenance.
But the problem I see from your end is that the policy doesn't define renovation. And the term renovation appears in the same clause as buildings under construction or renovation. So we know it's something different from construction, arguably less than construction. So is it a question of fact whether things such as repairing doors and windows, repairing leaky plumbing, patching windows and floors constitutes renovation, since it's not defined?
Okay, so the Arizona law tells us that for an undefined policy term, we're going to look at its ordinary meaning. In other words, what would the ordinary person think of as renovation?
Oh, no, we go to the dictionary. We don't worry about what the ordinary person would think because, we might think differently.
Well, the dictionary certainly can provide
I think that would be more helpful.
can provide support and help. Generally speaking, dictionary definitions of renovation talk about renewing or making new. And even if you think about the word renovation, novation from the Latin novare, to make new, is something that has at its core making new. So
That's one definition, but we've looked at several, as you may imagine.
right.
And it also says to clean up, replace worn and broken parts in repair, to restore to good condition, to refresh, to revive. So it seems, honestly, that definition is broader than what a lot of people might consider renovation. I think a lot of people think of renovation as construction, but we know from your policy those aren't the same thing.
Well, but they are analogous. Ordinarily, when we think of construction, it's likely building something new. And renovation, it seems to me, in the common understanding, and looking across the cases that we've cited to you, is going to involve doing something that renews or at least replenishes at the premises. The way I conceptualize it as follows: out with the old is not the same as in with the new. And here we have everything that is out with the old, but nothing that is in with the new. Look, if I see my neighbor with his garage door open, taking things out of his garage, putting them on the sidewalk, sweeping up and doing things like that for a couple of days, what is the ordinary person going to conclude? Is he renovating his house? No, he's cleaning out his garage or his house.
Well, that's why I said to Mr. Dow, I think if we were looking here at only changing light bulbs, cleaning the carpet, and touching up paint, this would not be a close call. But then I think when you talk about repairing doors and windows, even though you say it occurred due to vandalism, repairing plumbing, repairing walls and floors, that gets into a more unclear area.
Well, let's be clear about in terms of what we're talking about, quote unquote, repairing plumbing. If the toilet was leaking, Helmut, the other employee, would replace the guts of the toilet so it didn't leak, or put a washer in a faucet. And it raises an interesting point here. Ordinarily, the concept of renovation is going to at least involve some kind of construction activity. But look here, no permits, no licensed contractors are working at the property. There's no structural change. There's no dumpster outside the property. There is no business taking place at the property. There's no alarm system there. So the point is this, is that if you're thinking about the concept of vacancy and why is there an exception to the vacancy clause, we're looking to see if there is the functional equivalent of a customary operation taking place at the building, such that criminal activity would be deterred. And that's really not the case here. There is no functional activity. There is no functional equivalent of customary activity taking place. The property says that, the policy says that the property is vacant if there is less than 31% of it occupied and used for the owner's customary operations. Now, here we've got, at best, two guys on the property doing bits and pieces of maintenance that are required by Mr. Glasser. And I want to point out that I am not in disagreement with my opponent on this. In our briefing, we addressed a case called Veneman, which does tackle the issue of renovation and vacancy, but here's what my opponent says. This is at page 14 of the reply brief, talking about the Veneman court. One court indicated, and we agree, that the remodeling must consist of substantial continuing activities to fall under this exception. So, the court...
But Veneman also, I think, and I want you to correct me if I'm wrong, dealt with a policy that had an exception for a building, quote, being constructed, close quote.
Yes.
And as I read most of the cases you've relied on, those are cases that rely on construction. I haven't found one that had a remodel term. Am I missing something? And again, it's your client's policy, and so they obviously think there's a difference between remodeling and construction. And so I'm trying to find a case that deals with renovation versus construction.
All right. Well, and believe me, we searched. So,
I suspected you did. Yes.
But and secondly, just for clarification, look, it's not my client's policy. My client is the insurance agent who sold the policy. But
we won't tag you with that. But
yeah,
you know what we're talking about.
But we do have to live with the language because it's the language on which Judge Warner properly granted summary judgment. My thought in response to your question is that the overall concept of vacancy is something that you have to bring in to this particular policy, which is that, is it under construction? It's clearly not under construction. I know that they've argued that it is, but nothing is truly being constructed here, in fairness. So is it renovation, and is it substantial continuing renovation? They agree it has to be substantial and that it has to be continuing. Is it substantial continuing activity that is renovation, which would bring this within the exception? That's really the question. It's not just what does renovation mean. It is what the parties agree, which is that it's got to be substantial and it's got to be continuing. Here, it is maybe continuing. There is some presence, arguably, at the property most of the time, although it's two guys on a 5-acre property, so this isn't much of a this isn't much of a presence, but let's just say that it is continuing for the purpose of argument. Is it substantial? Is what they are doing substantial? I think that we can agree that changing the light bulbs isn't substantial, cleaning the carpet is not substantial, touching up the paint is not substantial, fixing the toilets and the sinks so they don't leak, not substantial, moving shelving, hardly, patching the walls where there are screw holes.
But why aren't those questions for the jury to decide? I mean, why are, I think as a matter of law, to say that all those things put together on a continuing basis, whether you think they're substantial or not, we could differ on that, and so could a jury. And so why aren't those questions of fact for the jury to decide? It just seems to me that you're listing all these things and saying that's not substantial, that's not renovation, that's not this. Counsel on the other side said, well, I think it is. The definition that Judge Downey read to you, to make like new, or to clean up, replace worn and broken parts and repair. I mean, those all seem like the list you just gave me sounds like renovation. Now, Judge Downey might not think they're renovation. There's a question of fact on that. Why isn't that more properly for a jury? If we were here today on a jury verdict that said this is renovation, that the jury has already decided this is renovation or has decided this is not renovation, I'd agree with you completely. The jury heard the testimony, but it just seems to me like this is kind of a question of fact. And even if they were minimal, the jury could decide that they were not. Quite frankly, I just had some tile put in, and I felt like that was renovation, but
No, what you probably thought was that it was a nightmare because we've all had contractors at the house doing things that we don't like. But in fairness, to respond to your question, though, can you roll these things together and say, well, they could all possibly be substantial if you put them together, and that's going to be a question of fact for the jury? Well, for one thing, Judge Warner didn't think so, but as far as the idea that a single dictionary definition would control what you believe to be the outcome, that seems to not take account of what we say is Arizona law, which is that you do need to adopt what an ordinary person looking at this policy would conclude is or is not likely to be renovation.
Well, but that then gets us to beyond summary judgment of what an ordinary person, and that's how juries decide things. We may well agree that, when I'm fixing my toilet or stopping, the sink from dripping, that's not renovation. But when I, 6 months later have to replace the toilet, it probably isn't, but I may agree because it took me longer than I thought it was going to, and I had to go back to Home Depot 6 times to get all the right stuff that it was.
Well,
I've been there.
Yeah, me too. But look, the easy call, honestly, is to throw it back to the jury. Jury question, why not?
Okay.
Right? That's the easy call. The tougher call, I agree, is to determine whether this is something that is substantial and continuing. And since the parties agree that what has to happen to qualify for renovation is that it's substantial and continuing, I think in fairness we are entitled to bring to your attention what did happen within the 60 days, exclude what happened before and after, and ask you to consider that that is really in the nature of minimal kinds of work that were needed just to keep the place up to spec, if you will. Not renovation, but more in line with out with the old. It is not in with the new. No permits, no actual construction, nobody doing anything truly substantial at the premises. It's being maintained and cleaned up, which is what the trial court found.
And well, what you're arguing is that based upon the evidence from the deposition that it was cleanup and maintenance, that it really doesn't amount to substantial and continuing.
It does not amount.
Does not.
It does not, and our idea conceptually, I'll return to it, is that what is the purpose of the vacancy clause? The purpose of the vacancy clause is to allow an insurer to not involve itself in a risk that is exposed to theft and vandalism, which of course is what happened here repeatedly all the way up to July 6. And so if we understand that that is the insurer's intent and the court is to give effect to it, then the intent has to be that construction or renovation somehow is the functional equivalent of the property being used for its commercial purpose or some commercial purpose. There is no commercial purpose involved here to where you've got two guys at a massive property doing not much at all.
Before you run out of time, do you want to touch on your cross appeal? And let me sort of focus on the issue I see. I understand that Mr. Glasser did plead a breach of contract action, but it's clear that the crux of his claim was a breach of duty, and the Wilkes versus Mano Bianco case, the insurance agents owe a duty of reasonable care. So why was Judge Warner incorrect in saying 12-341-01 doesn't apply?
Well, first of all, it's in his discretion. So,
well, 12-341, whether it applies or not is a question of law.
Right.
Then whether to award fees is discretion.
yeah, so this is an unusual case where they plead breach of contract, but there is, in fact, no contract that they can point to or establish in the evidence, and Judge Warner found as much. Our view is that Arizona case law, the Berthoud case in particular, allow for the recovery of attorney's fees where we establish that there is no contract.
So, a great case.
Did you write it?
No, I was litigated.
You must have won. All right, so
So-
your view is that just by virtue of them pleading a breach of contract claim and you winning on that, that triggered application of 34101?
Right, because we had to defend against it.
But really what you defended against was his claim that your clients breached their duty based on the relationship between the parties. I know they called it breach of contract, but was it really litigated as whether an actual contract existed?
Well, all those issues were certainly intertwined in terms of what we had to do to defend the case, and we believe that when there is that breach of contract allegation and we disprove the existence of the contract, we're entitled to attorney's fees when we prevail. I'm out of time.
Perfect.
Thank you.
Perfect timing. Thank you. And rebuttal, Mr. Dow?
Yes, Your Honor. Very briefly, we believe that this is a question of fact, that we have enough evidence for a jury to make a determination as to whether there was a renovation occurring on this. We do believe you do aggregate all of the things that were going on here in terms of what constituted renovation. Additionally, it wasn't as if the building was vacant, and the appellee points to that there was 2 guys over there working. They were working almost daily on the premises. But Mr. Glasser does not have a huge staff even in his present building. This is kind of the way he operates. He has maybe 3 people right now. So it's not that would be different from what they're saying here. This is a small, although he does a lot on the internet, it's a small employee-based operation. And selling rocks and beads and jewelry on the internet, you have to have a lot of space, and he had to have the appropriate space as opposed to an automobile facility that was there. And he was in the process of renovating it, changing it so that it could be utilized for what his present operation is.
How do you address the ostensibly the evidence that what was going on was cleanup and maintenance, and ostensibly maybe an admission in your reply brief that what was going on wasn't substantial and continuing?
Well, I think the quote admission in the reply brief was saying, even taking them at their word, we believe that this was substantial and ongoing. We didn't necessarily agree with that definition that they had, but we wanted to say, even if you take them at what they say, we should still be correct. But we also believe that this renovation term, if anything, would be the dictionary term or something that both sides would be arguing to the jury. And under these circumstances, repairing doors, windows, plumbing, sealing, painting, doing this, I consider that renovation. I certainly did at my house, and I've certainly, if we ripped out the carpet here and repainted this, there would be a sign that says this is closed for renovation. And that's what would be going on here. That at least...
We would say remodeling. We wouldn't say renovation.
Okay, remodel, renovation,
But and there may be a difference, but clearly you'd have to look at either in the absence of a definition. Then there may be an argument depending upon how we see the evidence.
Yes, and we do believe that given all of these, and even some of the stuff before and afterwards, it does show a course of conduct of what they were doing here in renovating and changing this into what would be his new headquarters there. So we believe that we have at least satisfied enough to get to the jury. Whether the jury decides in our favor would be another issue. Additionally, in terms of, and I'll just address this briefly, the attorney's fees, the court denied under 12-34101 the attorney's fees in its discretion. After analyzing the factors, we believe that the court appropriately analyzed those factors, and it should not be disturbed on appeal.
Wait, is that what the trial court did? Because that's kind of what Mr. Hassett was saying. I thought the trial court concluded 34101 didn't apply.
It said it didn't apply, but maybe I'm reading more into that, Your Honor. It said it didn't apply because the essence of this
The court
case...
concludes that fees are not awardable because this action does not arise out of contract.
Yes.
So to me, that's a question of law, whether Well, it's a mixed question of fact and law, perhaps. So let me ask you this. I know you weren't counsel of record when the complaint was filed, but
Yes.
count one of the complaint, breach of contract. And then it alleges that contract was breached, and then paragraph 63, this action arises out of contract, and Glasser is entitled to recover his reasonable attorney's fees incurred pursuant to ARS 12-34101. So your own client was saying this is a breach of contract action and that the statute applied, so why shouldn't we agree with you?
Well, you may agree with me, at least under that claim, Your Honor. I can see that, concede that was addressed in the complaint. I did not draft the complaint, but that was not the essence of what most.
Goldberg's a fine lawyer. and
He
he
is
did.
a fine lawyer. I've known John for 25 years. I'm not disputing that, Your Honor, but he did get sick during this period of time, and Mr. Oberg did get cancer, and I think everybody here is aware of has had to cut back considerably.
I actually didn't know that.
Oh,
so
okay. Well,
sorry about that.
that's what one of the main reasons I'm here today. Your Honor.
But so
I've known John like John.
So
that-
your argument is notwithstanding count one, breach of contract,
Correct.
notwithstanding the claim that this arises out of contract, that it really didn't?
Your Honor, I concede that part of it did arise out of contract, and we don't believe that attorney's fees should be awardable based on the basic normal factors that you would analyze. On that particular issue, we are going to go with what the court said. Of course, we want to uphold that issue, Your Honor, but I did not draft the complaint, may have drafted it differently.
But so your position is even if 12-341 applies, the court should have exercised its discretion not to award fees, which of course Judge Warner didn't get to because it said the statute didn't apply.
That's correct, Your Honor. And we would request that the court reverse and remand the underlying case and deny any request by the appellees for attorney's fees.
Thank you.
Thank you.
Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course. And at this time, the court stands adjourned. Thank you.